put it on record at this committee that if I get the opportunity, I intend to knock on the doors of Parliament, and I intend to work closely with Parliament, because the issues involved in lands and natural resources, you cannot be successful unless you work with Parliament. There's a lot of experts and people with capacity in this House, which I intend to tap in, and to work hard and to try to live above board in integrity. But Mr. Chairman, a lot of examples have been made across the world about age and the rest. But I have a homegrown example, which is that I take inspirations from the Honorable Minority Leader, whom in 2009 was made Minister for Communication at the age of 38. He was a year older than me, and that is an inspiration. So I believe if I marshal the correct attitudes, and I'm not too sure that the Honorable Minority Leader did badly at all as Minister for Communication.
You want to bring him into, and you know he may react to this matter. So just stay on safe waters.
Mr. Chairman, he did. I think he held his own as Minister for Communication at the age of 38, and I believe that if I stay humble and I stay focused, I should be able to contribute my bit. Thank you.
Well, thank you, Honourable Nominee. On exploitation of minerals in Ghana, Ghana is endowed with many minerals, of which studies have established them in very viable quantities. Over the years, the focus of the country has seemed to be biased on gold production or exploitation of gold, to the under-exploitation of other economically viable metals, and in particular industrial minerals, i.e. salt, limestone, clinker, and the rest. What direction would you provide, when given the nod, to focus other attention on these minerals, industrial minerals in particular, salt, limestone, clinker, with all the economic viability and the economic potentials they possess, to exploit them?
Thank you, Mr. Chairman. Mr. Chairman, I think by the grace of God, if I get a nod of this committee, I will have the benefit of expert advice, and I will also work with all the stakeholders in the industry and the ministry to be able to formulate policies for all of these areas. I don't want to pretend that I have all the answers here. And so whatever collaborative efforts will be needed will be done. But the member is very right. Salt is a very major mineral. It's a very important resource that we have to tap into. They call it the white gold. And Ghana is very strategic because we have enough commercial deposits of salt, which I believe we have to exploit. And the full value chain of salt has to be established here in Ghana. Mr. Chairman, for instance, you cannot build an integrated aluminium industry without salt. You cannot build the integrated iron and steel industry in Ghana without salt. The petrochemical industry cannot actually thrive without salt. So salt is extremely important. And so the measures that are to be put in place to develop salt fully, I know that the administration of President Akufo-Addo in his first term has made some attempts. Adasongo is one example where I know a mining lease has been granted. There's an attempt to exploit the salt there. But I think that it's gotten to a time where we probably should consider the establishment of a salt development authority in Ghana, whose mandate will be responsible for building the full value chain of salt in Ghana. Today, Mr. Chairman, Nigeria consumes a lot of salt, and yet Nigeria imports salt from far away Brazil, simply because we don't have a salt terminal in Ghana. The distance between Ghana and Nigeria is closer, and yet they still have to go far away to import salt. I believe if we get this authority in place where we can have a refinery for salt, we can have a terminal for salt, it will help a great deal. Thank you.
Thank you, Mr. Chairman. Lastly, on lands, does this concern on agitations for compulsorily acquired lands to be released? Honourable Nominee, when given the nod, what leadership will you provide to address compulsorily acquired lands to be released?
He just answered that question. He just spoke to that question. If you want to have another question, otherwise I'll move on. Yes, wonderful.
Thank you very much, Honorable Chairman. Let me first commend the brother of my roommate for this appointment. My first question to you is something very worrying. Recently, President Nana initiated the fight against Galamsey with the hope of saving the dissipation of our forests and water bodies. Evidence shows that some of the people who sabotaged the effort of the president were people within your party. What assurances are you going to give us that as much as possible, you will ensure that these people do not take advantage of political...
Are you mentioning anybody specifically? Otherwise, you assume that he knows somebody who sabotaged somebody.
Oh.
If not,
I said some of the people, it's clear. It's that this one is public knowledge. In fact, source.
Don't ignore their
former
side.
Minister for Environment.
Honorable, ignore their side and talk to me. Yeah.
What assurance are you going to give Ghanaians that you will not condone such of political apparatchiks using political influences to get into such a situation where they will sabotage efforts of a sitting president in mitigating some of these things that affect our environment?
Thank you, Mr. Chairman. Mr. Chairman, we all will acknowledge that in every government and in every dispensation, when you are rolling out policy or implementing policies, especially when you are dealing with very intricate, complicated areas such as illegal small-scale mining, you will have problems. There's absolutely no two ways about that. I have taken time to understudy a lot of the literature, and it is clear that when Honorable Inisa Hussaini was Minister for Lands and Natural Resources, he encountered a lot of problems, and he will admit it. When my uncle Alhaji Collins Dauda was Minister for Lands and Natural Resources, he encountered a lot of problems. When Honorable Peter Amewu went into the Lands and Natural Resources Ministry, similar problem. Honorable Asmachirem is not an exception. So I want to agree with you, Honorable Member, that in such crusades, in such fights, you will come across challenges. You will come across stumbling blocks. We all know it. It happened under NDC. It's happened under MPP. You have party people, you have big wigs who want to frustrate the situation. But what is important, and what I can say without a shred of equivocation, is that the President of the Republic, Nana Addo Dankwa Akufo-Addo, is absolutely committed to making an impact in this illegal small-scale mining industry. His policies were rolled out in the first term, and indeed, there were some achievements, there were some challenges. If I get the opportunity, my instructions from the President are that I should go there and keep my head focused and work hard to ensure that we reduce the incidences of illegal small-scale mining in our country. Mr. Chairman, look, anywhere you have extractive industry, here we call it Galamsey. In South Africa, they call it Zamazama, and it's a big issue in South Africa. You talk to the Minister for Mines in South Africa, you admit that illegal small-scale mining is such a big issue for them. So, yes, I agree with the Honourable Member's assessment of the fact that you will have people in your own party and chiefs and so on and so forth trying to frustrate the situation. But I want to give a firm assurance that I'm very clear in my mind that if I get the approval from this House, I am moving in there, and I'm not just talking, I'm moving in there to, in all humility and modesty, apply the law without fear or favor. That if I don't do that, I will set myself for failure. Thank you.
Mr. Chairman, the second question has to do with my people, and possibly the whole Ghana. There have been serious agitations among the people of the Greater Accra region that unfortunately being the capital of the country, government has encumbered a lot of their lands for the public good. Over the period, these projects elapse or government do not have use of these lands again. But instead of the lands reverting to the alluvial owners, government officials, public officials end up appropriating these lands and selling them to people, sometimes even foreigners, without recourse to the alluvial owners of those lands. What are you going to do to ensure that the policy that was embarked upon by the late President Mills, continued under President Mahama, would be continued, that those lands which were taken for the public good and government have no use for them again are reverted to the alluvial owners?
Thank you, Mr. Chairman. Mr. Chairman, yes, it's a major issue in our country. In fact, I should say that since my nomination and my announcement, and even before appearing before this vetting committee, I've also received a lot of delegations from my chiefs, my chiefs from the Savannah region, talking about this land and that land and the fact that land should be reverted to them and so on and so forth. So it's a major issue. But Mr. Chairman, with your indulgence, I think this is a very important public issue, which I'll seek your permission to try and explain a little bit so that the issues will be set straight. Mr. Chairman, the matters, the category of lands which are normally the subject matter of reversion, I will classify them under five different categories of lands. We're talking about lands which were compulsorily acquired before the promulgation of the 1992 Constitution. Two, we're talking about lands which were compulsorily acquired, but for which compensation was paid. We are talking about leaseholds, which the government is the lessee. The government acquired land from families or clans or schemes. Good. Number three. Third, we are talking about vested lands. And fourthly, we are talking about lands, we're talking about lands which were compulsorily acquired, but for which compensation was paid, but were acquired for stated purposes, which stated purposes are no longer the purposes for which the lands are being deployed. Mr. Chairman, when it comes to vested lands, I've already indicated that Act 1036 seems to have resolved that, which is that if I get the approval of this House, 6 months from 23rd December 2020, that is 23rd June 2021, I should be expecting a recommendation from the Lands Commission on specific vested lands and the various recommendations they will give for me to forward to head of state for action. So that is number one. Number two, the lands that are acquired for which compensation has been paid, for which compensation has not been paid, we need to look at paying compensation. I mean, and the Constitution is clear that compensation must be adequate, it must be prompt, and it must be fair. And there is a new culture which is evolving, which is that where you cannot pay with money, you can have some arrangement with the chiefs in order for them to take some of the lands as in lieu of compensation. And then you come to leasehold. Leasehold is not a difficult one. When the lease expires, the lessor or the grantor will determine whether to extend the lease or to have his or her land back. The real, and of course, when it comes to lands compulsorily acquired before the 1992 Constitution, in the case of Okudzeto Ablakwa versus the Attorney General, it was clear, it was determined that that provision of Article 20 does not apply to lands which were acquired before, compulsorily acquired before the 1992. The thorny one, the real difficult one, the big elephant in the room, has to do with the lands which have been acquired, compensation is paid, but the lands have not been used for the stated purposes for which the lands were acquired. Mr. Chairman, on that score, I will respectfully crave your indulgence to allow me to also point out some of the decisions of the Supreme Court of our country. I first will refer to the case of Obitetetru III and Attorney General, 2010 Supreme Court of Ghana Law Report at page 904, where the Supreme Court held, Mr. Chairman, quote, once the use to which the land is not to be put is not restricted to any personal or individual interest, but one to which the general public will have a benefit, or the benefits of the project will inure to the entire country, either directly or indirectly, the public interest purpose will be deemed to have been adequately catered for, end quote. So the import of this ruling is that even where land is acquired, compensation has been paid, the stated purpose for which the land is acquired is no longer the purpose for which the land will be used. If it will be used for a purpose which will inure to the benefit of the people, the requirement of stated purpose, stated public purpose, is satisfied. Mr. Chairman, in fact, in the case of Okujeto Ablakwa versus Attorney General in Obichebi Lamti, number 2, 2012, 2 Supreme Court of Ghana Law Report at page 845. The Supreme Court even went a step further. In the Supreme Court, the respected judge, Robe JSC, reasoned as follows and held as follows, quote,
Mr. Chairman, without rudely interrupting him, the way the nominee wants to elaborately answer a question, we may do 24 hours here on him alone. So if he can restrict the answers. No, it's not that I don't want good answers, but I understand he wants to elaborately make reference to ruling. It's good to answer questions, but if he answers them this way, the Speaker, Mr. Chairman, we are likely not to be able to vet more than him alone today. So if Mr. Chairman could guide him. Thank you for alerting us. Honourable Member, please be guided.
Mr. Chairman, thank you. I'm fully guided. I'm fully guided.
More follow up.
Yes, I'm fully guided, but I'll just respectfully, Leader, to say that I'm sorry, the issue of compulsory acquisition of lands and whether or not they should be returned to the original owner is a major issue. Even before I'm being vetted and before I'm being sworn in, hopefully, there are a lot of requests from all over the country. So I just thought that it's important.
But Honour Chairman, with your indulgence, Honourable Nominee, just hold it there. We've heard those cases you cited, but as guided by Chairman and the Honourable Whip, brevity should be the way. As for the references you have done, we'll read them thoroughly ourselves. But come back to compulsory acquisition. Go to Article 20, just your last words, and then contextualize it within subsection 5 and 6 of Article 20, not just the Supreme Court ruling. Chairman, with your indulgence, no property or any description or interest in or right over any property shall be compulsorily taken possession of or acquired by the state unless the following conditions are satisfied. So minimum, you have some conditions you must satisfy. Now, just the words you use, read what 5 and 6 says and give us an assurance to what Honorable Nilante wants from you. Any property compulsorily taken possession of or acquired in the public interest or for a public purpose shall be used only in the public interest or for that public purpose. We have seen people go for these lands, then use them for other purposes other than this. So first is what will you do about that category of land? Then the 6th, Chairman, where the property is not used in the public interest or for the purpose for which it was acquired, the owner of the property immediately before the compulsory acquisition shall be given the first option for acquiring the property. So take, for instance, Ghana lands or lands within the Greater Accra region. The state acquired it in the public interest. The state is not using it for the public interest. The chiefs are saying that respect the provisions of Article 26 and let it revert back to us. Will you do that if you become minister? Thank you, Chair.
Mr. Chairman, with the greatest of respect, if you will indulge me to just read the decision of the Supreme Court, it's just a paragraph. No, because otherwise I'll be misconstrued. I'm absolutely not against reverting compulsory acquired lands to chiefs. I'm very much not against it. On the contrary, I want to promote it. But the point I'm making is that the Supreme Court had an occasion to interpret the provisions referred to by the Honorable Minority Leader. And the interpretation they put on them, those were not my words respectfully, Mr. Chairman, Broby, speaking for the court, said the first point may be made on these provisions in that this court has, by a majority decision of 4-3, decided that Article 25 and 6 do not apply to the lands acquired compulsorily before the coming into force of the 1992 Constitution. It goes on and on. And it goes on to say the plaintiffs contended that the property should be retained for the purpose for which it was originally acquired. That will mean that defendant was to, that will mean that will be by the minister or any public officer. The grant to the second defendant was to develop the property into 3 blocks of flats of at least 4 stories. Which of the 2 uses will benefit the public more or satisfy the public purpose as required by the constitutional provisions? In the light of the explanations of the 2 expressions in TV3 case referred above, I take the view that the use to which the Lands Commission directed the second defendant to put the land will serve public interest or will be for public purpose. So, Mr. Chairman, the Supreme Court seems to have, they've given a settlement on this. But
that was your third question. That was your second question. Very well.
Honorable nominee, from your explanation, which I will say I won't hold you to it because you are not a member of the bench at that time. But let me say, don't you think this is the reason why politicians over the years have used their political positions to take over set lands for their personal use, commercial use? Why should a politician take a land that belongs to a family, it's 2, and build apartments for his personal use?
Honorable Nilante,
Yes.
There's no evidence before this committee that politicians...
I'm not hearing you, Chairman, because they are making noise about it.
There's no evidence before
Please, can you
this
shout?
committee...
Chairman is speaking.
There's no evidence before this committee that politicians are taking over public lands.
Okay, public officials. Public officials. Chairman, there are a lot of evidence. Chairman, I can give you evidence of this.
Well,
no, the issue
is
an legitimate issue.
It's very bad.
Please, it's a legitimate issue. This is a concern of my constituents.
Honorable.
Please, this is a concern of my. Please, Mutaka.
Sorry. Nilamte, I'm saying that you're tagging politicians as taking over public lands. I'm not aware of any such thing. If there's anything you find wrong anywhere, you know where to go. But please don't put the words in the mouth of the nominee. Ask questions that relate to.
Chairman, okay. Let's say, let me give you an example, perfect example. The Dowenya irrigation lands, which government, since the days of Achampon, took for agri purposes, today is being used as estate developing and all those. Or let me say, to the detriment of the alluvial owners of that property. What do we do to resolve such problems?
Thank you, Mr. Chairman. Mr. Chairman, I want to conclude on this matter by indicating that Article 257 of the Constitution vests all public lands in the President. Again, Article 258